All we have cause to plead, draw near. Give attention, you shall be heard. God save the United States, the great state of Florida, and his honorable court. Ladies and gentlemen of the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket this morning is Trotti versus Rick Scott, Governor. Mr. Padovano.
Good morning, and may it please the court. I'm Phil Padovano of the firm of Brannick and Humphreys for the petitioner David Trotti. With me at council table this morning is Joe Eagleton, also of Brannick and Humphreys, and Mr. Robert Slama of Jacksonville. Mr. Slama was counsel in both of the proceedings below, in the DCA and in the circuit court. After hearing the evidence in this case, the trial judge said, and I quote, "This was simply an effort to circumvent the Constitution, not to support, protect, and defend it." Judge Foster resigned before the qualifying in the 2018 general election period, but he set his resignation date, the effective date, 9 months in the future to a point just 4 days before the end of the natural expiration of his term. And of course, there was no reason for him to resign in the first place. He couldn't qualify for another term.
Mr.
Why he
Padovano,
did?
may I interrupt
I'm sorry.
you just to try to cut to the heart
Yes.
of really what we're talking about here. The jurisprudence of this court has interpreted the resignation as being effective when accepted, isn't it?
That's correct.
So we, in this case, then what we would have to do is overrule a number of cases to get to the point where you would like us to be.
I don't think so, Your Honor, and let me tell you why. And I think it would be helpful to start with the points where I believe that we agree. We agree that there's a body of case law in this court that says a resignation becomes effective when it is tendered and accepted by the governor. We also agree that this court has encouraged judges to resign in the future so that the work of the nominating commissions can be done and so that there will be a seamless transition in the service of the court.
Well, there's a hole in the constitutional framework, isn't there?
I think
It doesn't really describe exactly what happened.
I think not. I think these cases, Your Honor, basically were founded on a principle of good faith, that a resignation was actually going to be a resignation in the near future. Every one of the cases that you refer to, every one of them, the effective date of the resignation occurred before the general election. And in the first case in which it occurred, it involved the resignation of Judge Richard Fuller. And I think the resignation was before the qualifying, but after the qualifying had been concluded. But it was, I think, something on the order of July 31st, or maybe even September, and the court said, well, because there's going to be 6 or 7 months of nobody in the office, that is what we call an unreasonable vacancy. And they used the term the court used the term in that case, unreasonable vacancy. All of the other cases fall in that category. So what I'm saying to you, Justice Lewis, is I don't think that the court needs to modify its case law. I think that all the court needs to say is that when it decided those cases, it was contemplating a near-term resignation. I don't think the court had in mind that somebody was going to make a mockery of this by resigning a day before the end of the term and completely swallow up an entire election in the interim. I don't think that is what the court had in mind. So I don't really
It's not really what the court has in mind or any
Well,
politician has in mind. It's a question of trying to apply what the Constitution tells us.
Right. I think that this case is directly controlled by the case that the court decided in Specter v. Glisson.
But Specter, the Constitution has changed in Specter.
The Constitution did change, Your Honor, but not in a material way. Certainly the Constitution did change in some respects. The Constitution changed in the respect that, for the most notably, that we no longer elect appellate judges. Back then we were electing Florida Supreme Court justices. The Constitution changed in the respect that we now have a longer period for an interim appointment than we had. Well, actually, that changed several times since then, I think. But the material part of Specter has not changed one bit. The material part of Specter is if there is an election, the will of the people must be honored and we must have the election. Here, you have a case where there was absolutely no reason not to hold an election.
Am I correct in understanding that under the scenario that we sanctioned in, or authorized in Specter, there was going to be no physical vacancy in the office?
That's correct. That's correct. And I think...
Unlike,
I'm sorry.
Unlike what would obtain here.
Yes,
there would
yes.
actually be, it's small, but there would be some physical vacancy in the office.
Yes, Your Honor. I
So
concede.
that's a distinction.
Yes, Your Honor. I
Perspective.
concede that is a difference.
Let me ask you another thing that I think is related to Specter. Let me give you a hypothetical. Say that today, or earlier this year, there was a circuit judge with a term expiring in January of 2021. Okay? And that circuit judge decided that she wanted to leave office before the expiration of her term. Actually, quite a bit before the expiration of her term. Say about 2 years before the expiration of her term. But she also decided that she would like for her successor to be chosen by election rather than by appointment. So she announced in 2018, before the start of qualifying period, that she would retire effective on the first Tuesday after the first Monday in January 2019. Mm-hmm. Under your theory of our Constitution, what would happen?
I believe if I understand your hypothetical correctly, it would be an election, and I believe if I understand it correctly, that's precisely what happened in Specter. But
you think the judge there could decide that there's going to be a special election under the way the Constitution is now?
What I think, Your Honor, is that there's a big difference between deciding to follow the will of the people and to hold an election in an election year than deciding to try to thwart that. There's a big difference between those two things.
But Specter's about a special election.
Well,
correct?
Justice Ervin of this court, one might make the same criticism of Justice Ervin of this court. He did.
I'm not criticizing
I know
anybody.
you're not criticizing.
I'm just trying to explore where your theory of all this takes us, because what was involved in Specter was a special election that was set at the time of the regularly scheduled election, but it was still a special election for that seat. Correct?
Correct.
And the scenario I just gave you involved a special election for a circuit court seat. Correct?
I'm sorry, I missed the last point.
Was it so the scenario I described, the hypothetical here, would have involved, you're saying there should be a special election for that circuit court seat.
Right. But I think there's a difference between, like, for example, if a circuit judge might announce to the bar, I don't choose to run again, to let everybody know that the seat will be open. One might characterize that as a conscious choice on the part of the judge to favor an election. But elections are the default.
But what you're
in an election, this is an election.
In your response to my hypothetical, you're saying that basically the judge can decide there's going to be a special election to fill out a 2-year portion of the judge's term, correct?
I don't know. Perhaps I don't understand precisely the hypothetical.
I don't understand. Well, what don't you understand about it? I thought it was,
well,
I mean, I tried to be clear. Sometimes I fail.
I'm not laying that on you, Justice Kennedy. I'm just, believe me, I'm not. But I mean, in any event, we have a general election here. This is a general election year. It's 2018.
Well, I understand. That also was the case in Specter, but it was nonetheless a special election for that particular seat. It was not, the term was not up. So there was not going to be an election for that seat. And in the scenario I gave you, the term would not be up. it would be a special election. If I understand you correctly, you're saying the
I
judge can decide, as inspector, the judge can decide that there will be a special election.
I think I understand you better now, and I'm not sure I would answer that question by saying that it is an election, because that's a different situation. I think a very different situation from what we have here. This is
How's it different than Specter?
This is well, Specter actually was, he actually was aging out, I think, 20 days after. So he wouldn't have qualified for that. I mean, he wouldn't. I guess he could have. I guess he could have qualified.
He was going to be out by mandatory retirement, but the term was not up otherwise.
That's correct. That's correct.
So it had to be a special election if it was going to be filled by election, correct?
Well, there was a general election that year. It was a general election year. I'm not sure what the significance of the special, I mean, that was an election year. It was 1974. And there was, in fact, a general election that year. Candidates for the Supreme Court, in fact, some did. I believe Arthur England did. Some of them did qualify for that, tried to.
Well, let me ask you this. In our case, the letter was sent by Judge Foster prior to the qualification period,
Correct.
right? But it was to his term, by his terms, was to end way after the qualifying period.
That's correct.
What would be the result if he had sent his letter a week, a day, a week, whatever, after the qualifying period? Would there be an election here, or would we still be fighting about whether or not there would be an appointment?
That would clearly be an election. And that goes to part of this.
So we do get to the point where a judge can, by the date of the letter that is sent to the governor, determine whether there is going to be an election or an appointment.
Right. And that's correct. And what I'm saying is I don't think that it reflects well on the judiciary, or that it's consistent with the general, with the rule this court announced in Specter, to deliberately resign before the qualifying begins, knowing that that will create an appointment, when in fact you intend to stay there for the entire year.
Let me ask you this. What in your view is a reasonable vacancy?
The court...
I mean, so if he had sent this letter and said that I'm leaving at the end of October, would that be by appointment according to your theory?
I think it would be by appointment, yes, sir.
Okay, but the judge could do that subjectively to make it an appointment.
Yes.
So your concern is not really with the subjective intent, it's with the length of time.
I think that's correct. I think that's correct, Your Honor.
Let me ask you this too. Looking at the 2006 unanimous advisory opinion from this court, it says that under prior case law, a vacancy occurred in that case when you, the governor, received and accepted Judge Stevenson's resignation. And that's the point of law that you agree with and say should remain, correct?
That's correct.
Okay. And that goes on to say, because the qualifying period for the seat had not commenced, under this court's decision, and it gives the letter, the election process has not yet begun. Thus, Article 5, Section 11B controls, and the vacancy shall be filled by appointment.
That is all correct, but
now, if we were to follow that, then this would be an appointed position, correct?
But the difference, and it is a big difference, is that involved an actual vacancy, a fairly long term. I forget exactly how long, but I know.
But that wasn't part of the reasoning, was it?
Well, part of the reasoning in the previous case involving Judge Fuller talked about the fact that it had to be done that way because there would otherwise be an unreasonable...
It was a 7-month vacancy.
Yeah, I mean, because it would... Yes, Your Honor. Because it would otherwise be an unreasonable vacancy. To go back to your earlier question, I don't think the court defined what an unreasonable vacancy was. But I think that's probably a good argument for saying that the court doesn't need to define what is too short a time.
Let me ask a question just about the practicalities of this case and our precedent. Obviously, I agreed with you with your dissent in the prior Trotti case. It does the whole way our law has developed, including whether the vacancy or the letter is accepted before the qualifying period or right after, again creates an arbitrariness. So to me, I see that this should, whether it's solved legislatively, constitutionally, or by this court. But in this situation, it does concern me that we've got the alternatives we have is a judge who is in the wings, Judge Bass, who went through a judicial nominating commission process with, I assume, other qualified people, and we had the governor appointing him, and yet we've got Mr. Trotti, who apparently, he was, I guess, the same Trotti. Nobody else put in for the seat, presumably because they were relying on precedent. So it concerns me from a practical point of view that the choices here, at least here, but going forward, it may be different, is that we should stick with our precedent and let this go by appointment, and prospectively, if depending on what, make sure this doesn't continue to happen. What do you say about the fact that if the policy is we favor elections, there wasn't any election here?
Well, what I say about that is there was an election. If the Constitution calls for an election, it calls for an election whether one person qualifies or whether 10 people qualify. And I would also say that there is a provision in the Florida law that says what happens when only one person qualifies, and that is the person is deemed to have voted for himself or herself and is deemed and is not.
No, I understand.
I'm
just saying the reality is that we had one process that was a full process and another that, I would assume there are more people in the Fourth Circuit that would like to be a circuit court judge.
I think that's right. I think to answer your broader question, and it gets to a problem in this case, we're advocating for elections, and yet there won't be a contested election. There is an election under the law, but there won't be a contested election. I understand that concern. Let me just say, and that's a concern that the First District expressed, but let me just say that I think that once this problem is resolved, if the court were to say, we are going to adhere to what we said, Inspector, that if there is a machinery for electing, we're going to follow that because that is the will of the people. If lawyers out there get the idea that the court is willing to support the constitutional right to an election, then this isn't going to happen so often in the future. It has happened every year, as I pointed out, every election cycle, because in the first Trotti case, they gave lawyers the green light to do it. And it should come as no surprise to the First District Court of Appeal that there isn't much interest in elections. But I think the broader problem...
You are consuming your rebuttal time. If you want to keep going, you certainly may.
No, I do not, but...
I will give you an extra minute.
Well, thank you, Your Honor, and thank you for reminding me.
May it please the Court, Dan Nordby on behalf of Governor Scott. And with me at Council's table is Meredith Sasso, Chief Deputy Counsel for Governor Scott.
Can I just add a few things that still concern me about our definitions and our past jurisprudence? Okay. The vacancy occurring at the time that the resignation is accepted, yet an actual vacancy in this case and in the more recent cases will only be a matter of a day, 2 days, 3 days. There seems to be something unintended with that, that somebody, that although we understand maybe a month or whatever, what is that settled law? Is that through the Constitution, or has that been something that the court has created? Could you just, on the issue of when a vacancy occurs?
Sure, Justice Perriente. I think that is very long-settled law. I think actually Specter versus Glisson announced that principle, that the vacancy occurred at the time the resignation is tendered and accepted by the governor. It's also consistent with, I believe it's Chapter 114 of the Florida statutes, which says that a resignation occurs when the resignation is tendered and accepted.
But when have we talked, in what cases have we talked about an actual vacancy? Because here, Judge Foster, who couldn't serve another term, I mean, that's undisputed, it's been sitting and will continue to sit until a couple of days before the end of his term.
Well, Justice Perriente, in the 1992 advisory opinion involving Judge Fuller, and then I think more specifically in the 2006 advisory opinion, the Sheriff and Judicial Vacancies advisory opinion from 2006, involved a resignation that was tendered before the qualifying period and effective after the qualifying period. And in that case as well, this court held to its precedent that the effective date of the vacancy is the date when it's accepted rather than the date that it becomes effective at some later point.
Right, well, in that case, though, there was a true, he was resigning effective May 31st. So there was a 7-month vacancy, an actual vacancy. The other question I have, and then I know I stopped you at the beginning, is this idea, and I think it came from advisory opinion, is that if the resignation becomes accepted before the beginning of the qualifying period, it goes by appointment. But if it is after the qualifying period, it's by election. And I believe that was an advisory opinion. I believe there was either at least one dissent. What is that? What is the rationale? And again, the court would have enunciated it for what again seems to be a very arbitrary deadline when you know there's months ahead that there is going to be either, an election, and so you'd have to have senior judges in one case, and in another, you could fill it right away. Does that since we're concerned about the administration of justice, if the Constitution doesn't specifically speak to it, does that make sense to you?
Well, let me address both your questions in turn, Justice Pariente. First, on the question of the length of the actual vacancy, and picking up on something Justice Lawson mentioned in the earlier questioning, this court has not looked as part of its rationale in these cases as to the length of the actual vacancy. And specifically in the 2002 advisory opinion, when this court involuntarily retired Judge Harley here on the Leon County Court during the qualifying period, this court determined that that seat should be filled through the elections process, notwithstanding the fact that Judge Harley was involuntarily retired effective at midnight that same day, resulting in an 8-month actual vacancy in office. Notwithstanding the 8-month actual vacancy, this court said that the election process should continue because the election process had begun. So appointments have happened in cases where there are 7-month actual vacancies. Elections have happened in cases where there are 8-month vacancies.
I guess it sounds to me like the jurisprudence has created something that is not very jurisprudentially sound, is what I'm seeing here. That's my point, is that we have an opportunity to make sure going forward that the system can't be manipulated. Because again, and it's not Judge Moran did it, several judges, they all in their heart believe that merit selection is a better system, as do I, over election. But the question is, the voters have rejected that for trial judges, and haven't we created by our jurisprudence an unintentional hole where the system can be manipulated?
So let me address the broader question. As we've laid out in our brief, the Constitution provides that when vacancies occur in office, that vacancies are filled by the governor. And that's what the Constitution says. Now, this court in its 2002 advisory opinion stated that there is an exception to that after the election process has begun. Justice Lewis dissented from that opinion, as I recall, saying that he didn't see the language, the election process in the Constitution. But that's what led us to where we are now. And I think there's a policy rationale for that. This court said in the 2002 case, that was a vacancy after the qualifying period. Candidates were running for office, and in fact, we were on the eve of an election. And this court said, well, under those circumstances, maybe it doesn't make sense to allow the governor to appoint and nullify an ongoing election. So in the 2002 case, the vacancy occurred after candidate qualifying, and this court said the election process should continue. In the 2006 advisory opinion, the sheriff and judicial vacancies opinion, the vacancy occurred before the candidate qualifying period under very similar timing to the vacancy here, an April resignation for an office that would have been elected that November anyway, and there were candidates who wanted to run for that office. And this court said, well, the Constitution requires vacancies to be filled by the governor, and the qualifying period hasn't happened yet. The election process has not begun. And then, as I mentioned, the 2008 opinion, the vacancy occurred during the qualifying period. And this court said, we're not going to look to facts that are specific to each election cycle to determine how this process should be carried out. We're going to look to objective criteria. When did the vacancy occur? Was it before or after the beginning of the statutory qualifying period? So we don't need to look at the length of the vacancy, the specific needs of any trial court, the subjective motivations of the retiring judge. Was it before or after the qualifying period? So I think there's at least one rationale for that sort of approach being taken.
But is there a problem with the language that says that the vacancy occurs when you send the letter, as opposed to the date that you have indicated in that letter that you will be actually leaving, which would really result in a real vacancy as opposed to a theoretical vacancy?
Well, Justice Quince, I don't think that we have a disagreement with our friends here as to that line of precedent, and that has existed since at least Spector versus Glisson, and is consistent with the language of Article 10, Section 3 and Chapter 114 of the Florida statutes. And what that allows is for the judicial nominating process to begin, to result in nominations, and to result in an appointment for a seamless transition from one judge to another.
But on the other hand, I mean, I know circuit and county court elections are a little different from the appellate process, but in an appellate situation, generally, you know, you get to if someone gets to the end of their term, such as Judge Foster would have at the end of his aging out, the process starts because the Constitution requires, you know, at least 60 days before the actual vacancy. And so why isn't that just as a good a process to have in the circuit court situation?
Well, Justice Quince, I think there could be different policy arguments about what a better system was. I know Justice Pariente's concurring opinion in the Pinkett case from 2 years ago suggested maybe a clarifying constitutional amendment would be one way to address this. But as a matter of current precedent and the current constitutional language, I don't think that there's any dispute that a vacancy occurred before the qualifying period, and this court has said in every such circumstance that vacancies occurring before candidate qualifying are filled by the appointment process.
What is the executive branch's view if we would have a circumstance and this court would say, well, we've created a law, jurisprudence that talks, that's really a theoretical vacancy. It's not a real vacancy. And certainly you can't stop judges, other officers from resigning. I mean, that's part of, you know, what happens. But the Constitution does not provide for a year's wait time. It's not constitutionally enshrined. That's something that we've allowed to occur. So what would be the executive branch's view if a court would say, well, you know, the vacancy, this court has said that it occurs when it's tendered and accepted, and individual judges do not have the power to subvert the will of the people expressed in the Constitution. And it's not what we want, what you as lawyers want, it's what the Constitution says. And although I may prefer, as many do, a merit retention system, we don't have it for our trial judges. So what would be the executive's response to an opinion or a thought or an argument that would say, we should not let judges or politicians manipulate what the Constitution has clearly set forth, and that is that it occurs when tendered and accepted?
Well, Justice Lewis, two responses to that. One more on the law and one more of a practical response. Sure. So on the law, the Constitution does provide for a merit selection process to fill vacancies at the trial court level in Article 5, Section 11.
Okay. True.
And that's the circumstance here is to fill a vacancy in office for a limited term, for a 2 to 3 year term, followed by an election for a full term. The more practical consequence is that we've not seen any argument from Mr. Trotti at any level about what rule he's asking this court to adopt that would not allow a judge to resign in a way that would ensure an appointment or an election of his or her successor. If this court were to say
well,
that...
because, I mean, that we're talking in terms of what's theoretical, that's a vacancy, but it's not really a vacancy. It is that letter says, I'm not going to leave until the day before my term expires.
But Justice Lewis, if this court were to say that a vacancy could not be effective until after the general election or in December and have that
Well, how
filled
about
by
saying you
appointment?
can't fix it, that if you want to resign, go ahead and resign, and the terms of the resignation become effective, as the Constitution says, that when accepted by the executive.
Well, I think that actually was something that Mr. Trotti suggested on page 30 of his brief, that this court find that resignations effective in the future are unconstitutional. I think that would be a dramatic departure from this court's precedent to require
Well, I don't know if it's
only
unconstitutional.
immediate resignations.
Well, I don't know it's unconstitutional. What prohibits that?
Oh, I don't believe that it does. I don't believe that anything in the Constitution does that. The petitioner suggested that on page 30 of his brief, that this court might decide that resignations effective too far in the future are unconstitutional. But those have happened throughout this state's history.
It would be effective as of the date given. To me, it's an affront to the people of Florida to have judges that can manipulate the heart of who we are as a democracy. That's our Constitution. And I think what the trial judge here had to say is that's what this is doing. And I'm looking to see if there's not some other legally sound, but a better way.
So just so I can understand, so Justice Lewis, your suggestion is that if a judge wants to resign, that resignation must be effective immediately? It cannot be delayed?
Right.
If the resignation of Judge Foster had happened effective immediately in April, if that were the result, then I don't think there's any question under this court's jurisprudence that that vacancy would have been filled by appointment
Fine.
rather
So be
than
it.
by the election
So
process.
be it. My problem is with the charade that's being played. He's not really resigning. Let's face it.
But wouldn't the problem with such a rule be that it would, that would make every resignation effective immediately? So you turn in your resignation, it's effective, you're out the door. That would essentially guarantee that there will be probably at least a 2 to 3 month physical vacancy before the process, the merit selection process and appointment process can do its work.
I think that's absolutely right as a practical matter, and it could even be a 5 or 6 month vacancy if someone
Well,
appointed from
we
private
have
practice.
senior judges, and the legislature has provided for those. And there are, let me tell you, there are hundreds of senior judges around the state that there's not the senior judge hours for them. So why not plug those in until whatever you need?
Well, again, Justice Lewis, that would be contrary to a number of opinions from this court suggesting that judges should resign effective in the future to allow for a seamless transition.
Well, I'm not sure those are reasons soundly. To say that, oh, the courts are overworked and they can't do this. You know, I've been up here 20 years. And in watching what's happening now with what's going on in the trial court system, I respectfully, I just can't see why senior judge individuals could not, I mean, more than adequately handle that. I mean, we approve all the senior judges. They come through our, through our conferences, and it's pages and pages and pages of them. Rather than, my concern is that the people think this is a laughable situation. Only lawyers could say, you have a vacancy when the letter comes in, but you don't have a vacancy until 10 months later because one judge decided that's what he or she was going to do.
Well, Justice Lewis, if this court were to say that Judge Foster's resignation should be deemed to be effective immediately as to on April 23rd when it was accepted by Governor Scott, then the result of this case would be to affirm the First District on other
I
grounds through
understand
the
that.
appointment process.
But we're talking about trying to find what's a rational and reasonable reading of the Florida Constitution as to how it should operate when people resign. That's really what we're talking about this morning, isn't it?
Mr. Norby, just one question, and I'm asking this because I don't know. Is it possible for someone to withdraw a resignation? What's the effect if I change my mind, Governor? I don't want to resign anymore. I still have 6 months left in my term.
Justice LaBorga, I think under this court's precedent, it is possible to withdraw a resignation up until the point that it has been accepted by the governor.
Okay.
And how does the governor actually accept the resignation? By the convening of the Judicial Nominating Commission, or does the governor send a letter back saying, I accept your letter of resignation?
The latter. The governor sends a letter, formally a written letter accepting the resignation, and then separate correspondence asking the Judicial Nominating Commission to convene.
So there could not be a situation where I resign, the governor convenes the JNC, people are nominated, he makes an appointment, I don't like the appointment, Judge, I withdraw my resignation. I still got 6 months left in my term.
I think that's right, Justice Labarga, and actually that was addressed in Specter versus Glisson, whether Justice Urban's resignation should be deemed to be irrevocable, and I think this court concluded that it was properly deemed irrevocable.
Let me ask you on this, dealing with this case. So there is a judicial candidate who's been nominated and is serving at this point as a county court judge. If we agree with your position, either by coming up with what Justice Lewis has suggested or going with the First District, then he would be have to run for election in 2020. Is that correct?
That's right. If the governor has announced his intent to appoint County Judge Lester Bass to the seat, if this court will permit it.
So it would be, so he would serve for a year, and I'm just doing the math, it's
Right.
about a year.
He would serve until the next general election that's more than a year away, so that would be the 2020, I guess August, presumably, 2020 general election.
And then election, I mean, so we understand too, this only appears to occur when these, well, I'm gonna call manipulations of recent, good motivated, intentions, occur in the even-numbered years. Is really when a vacancy occurs in an odd-number year, because I always have to try to explain why some get selected through merit selection and others elected, there is no question that in those cases, those seats are filled by merit selection. Is that correct?
I think that's right. I can't think of a counterexample of that. This seems to come up in even-numbered years.
And in cases really recently where everybody can't even run again. I mean, so this isn't even, that's why these 2 or 3 situations that have come up not where somebody is sick or, is unqualified, but where they intentionally are leaving 2 or 3 days before the end of their term. I mean,
I think that's
we
true.
haven't had that.
I think that's true in some cases.
Well, again, the cases in the recent years are all that situation, correct?
Yes, we've also had judges, though, who leave and submit a resignation effective the end of December after the candidate qualifying period. And in those cases, the election process continues.
Then, again, that goes back to what Justice Lewis had dissented, is to say, where do we come up with that one? Right. So, we created another arbitrary distinction.
Right.
Perhaps.
And so what we would ask this court to say, consistent with the 2006 advisory opinion in the sheriff and judicial vacancies case, is that to any attorneys, such as Mr. Trotti, who wish to run for this office, the seat will be up in 2 years. If they want to run, they can. It's a limited initial appointment, and they can run for that seat. I did want to respond. Well, my time is up.
Since I'm going to give opposing counsel an extra minute, I'll give you an extra minute.
Thank you very much. Just to Justice Lewis's earlier point about Specter versus Glisson and some of the issues that have changed since then, I think that the most important difference between now and Specter versus Glisson legally is the adoption of the 1996 amendment to the Constitution. Specter versus Glisson had as one of its central premises that the people wanted vacancies filled through the election process at the earliest possible opportunity. By extending the initial appointed term for up to 2 years beyond the closest election in 1996, I think the people undermined that premise of Specter, and that's another reason why Specter should be legally distinguishable.
I do have one other question. Am I correct that the issues that we've been discussing were decided in the 2014 first DCA case, Trotti 1?
Yes.
Okay. And am I correct that the parties in 2014 sought review in this court and it was not granted?
That's correct.
And what was the legal issue actually in the case we're currently here on today?
We believe the legal issues and largely the factual issues are largely indistinguishable between the 2014 Trotti case.
Well, there was a big difference.
Wasn't the issue whether the trial judge erred in granting a preliminary injunction?
The vehicle was slightly different in the two cases. In the 2014 case, Mr. Trotti sought a petition for a writ of mandamus. That was denied by the Circuit Court and denied by the First District Court of Appeal. In this case, a declaratory judgment was sought. It was granted by the trial court and then reversed by the First District Court of Appeal. So procedurally, there is a difference.
Am I incorrect, because maybe I'm misreading it, but I read the case that we're here on is simply holding that because of the 2014 opinion, Mr. Trotti could not show a substantial likelihood of success on the merits, and therefore an injunction was incorrect. So that the court did not redecide any of the issues that were decided in 2014. They just determined in this case, the holding was that the trial court was bound by that case. Is that an inaccurate summary of the case that we're actually talking about today?
Justice Lawson, I think it's accurate, and that's the view we expressed in our jurisdictional briefing.
Okay.
So we would ask this court to either discharge jurisdiction as improvidently granted or to affirm the First District's decision.
To go to a point that counsel made near the end about the 96th Amendment, all that did was it lengthened the term of an interim appointment, but it didn't make it more permanent. It didn't change the relationship between Article 5, Section 10 and Article 5, Section 11. And I would like to just read you one line from Ployce versus Christ, Justice Labargo's opinion in Ployce versus Christ, citing Specter. This was 2009, long after the 2006 Amendment. The nominating commission process is really a restraint upon the governor, not a new process of removing from the people their traditional right to elect their judges. It goes on to quote at length Specter v. Glisson. Every member of this court signed that opinion, with the exception, of course, of Justice Lawson, who is not here then. Let me make one other point about, if I could focus in a little bit on the difficulty we're having here. I don't think we disagree about the body of law that says a vacancy is created if the resignation occurs before the qualifying. The problem is, what is a vacancy? Is this a vacancy? Would you be satisfied? The trial judge said this was an artificial vacancy. I think that's a good way to put it. And my question to you is, would you be satisfied if somebody resigned, if a circuit judge resigned 15 minutes before midnight, effective 15 minutes before midnight on the last day of his or her term? No work is being done. The courthouse is not even open. But now we're going to have to blindly and reflexively follow this rule that says, well, you know, the judge submitted the resignation before the qualifying. There isn't any real difference between that example and what has occurred here. There isn't any real difference between that and Specter. Specter didn't turn on the fact that Justice Ervin resigned in the last day or the day before or the week before. The whole point of Specter was that there was an intervening election and that the citizens had a right to elect their Supreme Court justice in that election. So
would you also agree that the issues that we're talking about were decided by the panel that you were on in 2014 in the first Trotti case?
They were, but I disagree that this was merely
and that would you agree that the issue on appeal, as stated in the opinion that we're here on, is whether the trial court erred in granting an injunction on the basis that there was no substantial likelihood of success?
The trial court...
Is that the way the court framed the issue in the opinion that we're here on?
No. The trial court fully reached the merits of the issue all over again. The trial court said that it was...
I'm talking about the appellate opinion.
I know you're questioning me about jurisdiction, and I know that jurisdiction, I respect the fact that jurisdiction is always open in this court. I respect that.
Well,
but there's no question about it.
As much as we want to decide a case, if we don't have jurisdiction, we can't.
But in this case, the First District said it made its decision in this opinion, the 18 opinion, not the 14 opinion, based on the language of the Constitution. The first line of the state's summary of the argument is that this case turns on an interpretation of the state constitution. So the court, I think to answer your question, the court actually denied an injunction because it didn't agree with us on the merits. The court reached the merits all over again.
Let me ask you, I have to ask you one other question, because you just said that if there's an intervening election, that makes the difference. So if Judge Foster has sent the same letter and said, I am resigning as of October 31, 2018, 6 days before the election, this would be an appointed seat. You would agree to that?
Yes, I would. Yes, I would, Justice
So,
Quinn.
so
And I-
in
because I
your
think-
mind, it all turns on whether or not there is in fact an election between the
Yes, Your-
before the date of the resignation.
Yes, Your Honor, and that's not just in my mind, that's what Specter says. And it says also that the only reason to make an interim appointment is the emergency of the public business. Now, I would ask you, is 4 days, are we really going to say we have to appoint somebody for 4 days? And if I could make just one final point, I'm actually over just
Very-
one
very
sentence.
quickly.
Yes, I will. Specter says that if there is any doubt, that the will of the people have to be upheld. And so if you go back to the conference room and you're having trouble with it, I suggest to you that the answer is that this should be an election and that you should quash the decision of the district court. Thank you.
Thank you. We thank you both for your arguments. We'll now move forward to the second case on today's docket, Brown versus the State